Welcome back to one more session of Adraas. It's a real-time dispute resolution mechanism. Today we have with us a very special guest. That's Mr. Jawad. For those who don't know Jawad, which is very rare considering his outreach, Jawad is an advocate who's based in Chennai with more than 30 years experience. He's also an arbitrator and above all, he's a mediator. Mr. Jawad has more than 30 years experience as an advocate who's based in Chennai, and he's also an arbitrator and a mediator. I trained under Jawad for my mediation program. So professionally, I'm well acquainted, and Jawad has a very nice, fine technique of resolving disputes. So let's hear from Jawad on, and you'll realize his style of working. The topic for today we have chosen is judicial intervention in arbitration. So that's a very broad topic. We have judicial intervention at different stages: before arbitration, during arbitration, or even after an award is passed. So, Jawad, can you please share your views on this topic and maybe we can narrow down to some specific questions?
Yeah, sure, Pradeep. See, basically, what is arbitration? It is just another adjudicatory process, just like litigation. Okay, when you go to court, instead you go to an arbitrator. So essentially, it's an adjudicatory process with a neutral third party, which in litigation happens to be a judge and an arbitration happens to be an arbitrator. Now, the only difference here is that you're choosing your arbitrator and you're going before the arbitrator. Now, where the judicial intervention really starts is there is a provision under the Arbitration and Conciliation Act, which is basically Section 9, where you need some interim orders. And that is when you go to the court and say that please pass interim orders because we are starting an arbitration and there's an apprehension that the other party may do something or may not do something. So you go and get some protective orders or whatever restraint order, orders that restrain somebody from doing something. So that is the first step of judicial intervention. Now, one of the unfortunate things about the Indian arbitration scene is that we don't have a well-developed institutional arbitration system in India. We hardly have any institutional arbitration at all. We don't have any arbitration institutions. Now, as a result of that, what has happened is we have ad hoc arbitration, which simply means that you have an arbitration clause in the agreement which doesn't name an institution, but the appointment of the arbitrator is dependent on the parties' agreement, unless, of course, there is a named arbitrator. Now, most of the agreements don't name an arbitrator because you don't know when the dispute comes up whether the arbitrator is going to be there or not going to be there, whether the position changes. Now, some public sector contracts or some big companies are involved. They name somebody from the organization as an arbitrator. But what happens is basically you say that you will agree to appoint an arbitrator. Now, it can either be a sole arbitration or it can be a tribunal consisting of 3 arbitrators. Now, in sole arbitration, what happens is you have a dispute, you issue a notice to the other side saying, hey, look, we have a dispute, please appoint, we are suggesting so-and-so as the arbitrator, please give your concurrence. Or we call upon you to agree upon the name of an arbitrator. Now, the other side who's already in conflict with you, if they respond and if they agree to your arbitrator, well and good, which invariably never happens. Or if they suggest some other name and you don't agree to that, then you're again stuck. And if supposing, both of you are not able to agree upon, you issue a notice saying that let us agree upon the name of an arbitrator, and the other side doesn't respond to that or doesn't come up to discuss with you and appoint an arbitrator. Now, here is where Section 11 comes into play. So you have to go to the High Court in the case of domestic arbitration, the jurisdictional High Court. If it is an international arbitration, you go to the Supreme Court. Now, earlier that power was, in the hands of the Chief Justice. But subsequently, what happened was the Chief Justice got the power to delegate that to any other judge. So when you go to the court for the appointment of an arbitrator, it takes a little bit of time. for the court to dispose it off. So there you are stuck in the court for some time. And then, though you may suggest an arbitrator, the other side may suggest an arbitrator, the court has the discretion to appoint their own arbitrator. And most of the time for high stake disputes, it's a former judge of that high court, or, if it's the Supreme Court, some former judge of the Supreme Court. So, and once the arbitrator is appointed, the arbitration proceedings start. Now, the other thing that if it's a tribunal, sometimes what happens is you may nominate your arbitrator, you have every right to nominate, the other side cannot question that. So they come forward and nominate, but then there has to be an agreement between the two arbitrators on who should be the presiding arbitrator. Now, if there's a dispute on that, then again it goes under Section 11. So this is where the judicial intervention happens in the second level.
Well, let me share a couple of things there.
Yeah.
Well, when you talk about appointment of arbitrators, I had the most luckiest situation where I got an arbitrator appointed within a month of filing Section 11. And in another case, it's been pending for more than 3 years under Section 11.
Yes.
So I have the two extremes.
Yes.
And I'm facing that.
Yeah.
But at the same time, let's not talk about Section 9 for a second. Let's talk about Section 11.
Yeah.
I have seen one or two applications where judges do a preliminary, at least at the threshold level, they see the limitation is barred, or if the arbitration clause is not proper, or the contract is not proper, the judge does not go forward and appoint an arbitrator. So in those situations, again, we are going to court, and that's where things are happening. So what is your view on those aspects specifically?
See, there are, the earlier point of view was that the job of the judge who appoints, that is the Chief Justice or the Chief Justice's delegate, his job is to only, it's a very ministerial function, and you can simply, you have to just appoint the arbitrator, and it's for the arbitrator to decide on the arbitrability and the jurisdiction and the limitation and all these things. But there have been some, I think, conflicting cases. Okay, I don't want to go too much into detail on those cases, but there have been different cases where they say that the appointing judge has to apply the mind to see on the arbitrability, on the limitation aspects and all that. Okay. So that is where the matter gets prolonged under Section 11. Because there is a back and forth, there's an argument that has to be advanced, the judge has to be convinced, and all those things. So that is one of the causes of the delay that may happen when you go to the court for the appointment of the arbitrator. Now, that is where I think to reduce that, the best thing is to name an institution.
But let me just take, for the sake of discussion, the complete opposite view and say that if I am not having a contract with you or a proper contract with you, or even if we had a contract, all the claims are long and dead claims. I mean, not just on the borderline of 3 years, but let's say 5 years or 10 years. So significantly time barred, very crystal clear.
Yes.
But as one view goes, the arbitrator is appointed and the parties are thrown into this arbitration. Why would I be interested in fighting this case when it's a dead case? But I have to go through the entire process and hope that the arbitrator sees the view in that and dismisses the case. Otherwise, I have to go complete the process and then go to 34 and challenge the award. Now, what I have seen invariably is that most arbitrators, I don't want to use the word all because there are very few good arbitrators and I salute them. But most of the other arbitrators, they want their fees. So if they preliminarily dismiss an application, they don't get the full fee component. That is a negative incentive where we are asking the arbitrator to do a function compared to a judge who just takes a salary on a monthly basis irrespective of the outcome of that case. So there is some vested interest of the arbitrator.
I think that is a very valid point that you have raised. That's the ground reality. I cannot but agree with you on that aspect. Okay, so why should I subject myself to an extra cost and an extra time and the process itself to undergo the process when it is a dead claim and there's either there is no contract or it is barred by limitation, whatever it might be. my feeling is that, see, one of the options would be to raise a preliminary objection. If supposing, let's say that you have institutional arbitration, and between party A and party B, there is a dispute, and there's a named institution. Now you go to that institution and ask the institution to appoint an arbitrator. Now, when the institution appoints the arbitrator, now I don't want to comment anything on the kind of arbitrators who get appointed. So we all know what those issues are. So we don't have to really name them. So people who are involved in arbitration, if they're watching this video, they'll know what we are talking about. We don't have to really spell it out. But in the institutional case, I think the possibility is that you may raise a preliminary objection on the issue of jurisdiction, right? And get the arbitration closed.
But see here, who would be making the decision? Would it be the arbitrator or the arbitral institution? In fact,
Will be, see, in the case of the arbitral institution, that is very clearly a ministerial function. They cannot go into the merits or demerits of the case and decide. So it will have to be the arbitrator.
and that is where the problem lies, because ultimately you end up once again in the room of that arbitrator. And as I said, there's a vested interest in some of these people. And in fact, I'll just kindly go off topic here onto that grading of arbitrators and other things that's already in the act, but it has not been notified.
Yeah.
Is that if that comes into place, and then these type of matters are somehow graded, then arbitrators will have more responsibility.
Yes.
They will be more constrained to behave properly. Let's just put it that way.
True.
There will be somebody grading them and watching their every move, at least not on a daily basis, but on the award basis.
I just want to ask you something, because when I'm appointed as an arbitrator, I strictly go by Schedule 4. So what is the significance of Schedule 4 now? When you appoint some other arbitrator, are the arbitrators following the Schedule 4? Because
Okay.
I think there was a recent judgment of the Supreme Court which gave some amount of flexibility on the Schedule 4 itself, and has opened up different loopholes in that, so that arbitrators can really exploit those loopholes and
See,
collect a higher.
it's always the case about balancing.
Yeah.
And as long as the parties accept, the arbitrator can ask for any amount of fees. And parties don't want to upset the arbitrator, especially in the initial stages itself. And they're acceptable to a fees which may be slightly double or 3 times of that Schedule 4.
Yeah.
But I'll ask you a question in return. Schedule 4 was enacted in 2015, right? And we are still using the same rates without any inflation. Next, the Schedule 4 is a model fees which says this is the fees. Let's say the upper limit is 30 lakhs for the claims and 30 lakhs for the counter claims. So that's maximum 60 lakhs. Let's say you have a case of 20 crore plus 20 crore, which is more than 40 crores.
Yeah.
And the upper limit is 60 lakhs. You'd be paying the 60 lakhs to a fresh graduate out of law school who's got empaneled as an arbitrator, and the same amount to a retired Supreme Court judge. How fair is that?
I wish fresh law graduates are appointed as arbitrators in those kind of cases, but where are they getting appointed?
That's a different topic, but at least what I'm trying to say is that the fee schedule is the same, whoever you pick. Now that is itself is not a proper or a good standard.
In my opinion, I don't think so, because I don't think that kind of grading really applies, because senior judges and junior judges get the same salary.
Not, okay, forget judges. Now talk about a person with 5 years experience,
Yes.
10 years experience being appointed as arbitrator. Compare that to a 30-year experienced judge, and this person has zero legal background. Who would you prefer? This 5-year or 10-year experienced non-legal person versus a 30-year experienced retired judge?
See, the question is, I would naturally prefer somebody with more experience.
Yes.
But my question is, why should I pay more fee to the person just because he has more experience?
Because that experience brings us some clarity, at least that the award may not be that easily set aside. There's not a guarantee, but a hope. So how can we have everybody on the same pedestal and say that the same fees would apply? These are never-ending debates. We can keep on and on.
Well, that gives me some hope that, I don't have to go by Schedule 4. We charge a higher fee here afterwards when I'm appointed as an arbitrator. Right. So, well, I think that is Section 11, as far as Section 11 is concerned, that we have been discussing about the appointment of the arbitrator. And in any case, invoking Section 11 is going to be quite a costly affair, because when you go before the court, you are engaging lawyers again and you're paying a fee for that, right? And as with the arbitrator, you need to appoint somebody really strong, somebody with 20 to 30 years of experience, who's got a pouch in the back, who's a designated senior advocate, who goes and argues, who can effectively put across your case, because the question of maintainability has to be decided by the judge. So of course, you may look at it as a cost-saving exercise, because ultimately, if you succeed, you don't have to go into the arbitration, then it suits you. But what if you want to go for the arbitration because you're on the claimant side and you really need to go into the arbitration? There again, you have to pay quite a substantial amount of money to get somebody who's really effective before the court.
Yes.
Okay. So these are all extra costs that you're incurring. And that is where I think institutional arbitration will be helpful, because you can always raise a preliminary objection, pay the same senior advocate, bring him to argue or bring her to argue before the arbitrator that this is not maintainable. So anyway, that is going to be a cost, whatever the cost may match, but at least you're not spending so much of time before the High Court or the Supreme Court in getting an arbitrator appointed. Okay, now many times we see orders where courts appoint an arbitrator and say, let the arbitrator decide on his jurisdiction. So what happens over there? So you again go back to before the arbitrator and then file an application saying you have no jurisdiction.
These are questions that are never ending. But anyway, we are reaching the end of our time.
That is why you and I have become mediators, right?
Well, I'm still more of an arbitrator guy rather than a mediator guy. I'm still slowly entering the mediation domain. It's going to take some time, obviously. But in the meantime, arbitration is what I'm taking care of. Just for information, I was recently appointed by a court as a sole arbitrator.
Okay.
So our courts are not just appointing judges; they're also
No,
appointing.
they are. See, that is where I have been appointed several times by our High Court as an arbitrator. I'm not complaining about that. But they have a sort of a criteria, like claim above 1 crore. I think they have some slabs over there to appoint, whether senior advocate or designated senior advocate or judges. They have slabs where they decide whom to appoint. And I think the Chief Justice of India has been very strong on this issue, that judges alone should not be appointed as arbitrators, and opportunities should be given to others also. So let's hope for the best. And in the meantime, let's hope that mediation works and people opt more for mediation, because much cheaper, much more cost efficient process, and the control is still in your hands and you get to call the shots and you decide how you want to resolve your issue.
Well, this is what you say, but other people that I have talked with, they say that mediation is tough, and because they say that I don't have any control over the process, and people like to be in control. At least this is the complete opposite view of mediation, but that's how things work. Eventually, one of these two will gain, and probably mediation will gain because of certain inherent qualities in that. But until that date, we have to keep on debating on this.
Yes.
As a closing remark, I'll just say one thing which is not a new saying, but we all heard it before. We are litigating in the court so that we can go to arbitration, which is a non-litigation.
Yes.
So with that, unless you have anything else to say, we can.
No, nothing. Just to say that these two things are inherently one and the same thing, basically. So you're just choosing your forum, and it has become as time consuming, as expensive, if not more expensive than litigation itself. So in my perception, I think arbitration has lost its the value it is supposed to bring for the litigants. So it doesn't really bring any value, and that is where I feel that I think there should be perhaps a little extra cost, but at least try mediation and then go for arbitration litigation.
Okay, thank you, Jawad. That was a good ending message. With that, I thank you for your time, and we'll see
Thank
you next
you,
time.
thank
Thank
you
you.
so much. Bye.